Bankruptcy is the only law in the U.S. Constitution. There's the Fourth Amendment, the First Amendment, Second Amendment, freedom of speech, freedom of religion, all the amendments. And everything in the Constitution talks about how many people are in the Senate, how many people are in the House, and what the states can do and not do. But nothing in the Constitution talks about law, talks about criminal law. Nothing in the Constitution says something is illegal. But bankruptcy is in the Constitution. Bankruptcy is the oldest law probably known to man except murder. Right. They had bankruptcy in Rome, and it's still the same. And it has gone all the way up through 3,000, 4,000, 5,000 years. And bankruptcy has stayed the same. Bankruptcy is not, I've told you before, like if you go to the law school, you can find the legal books that fill this room, and you go through there and you look for North Carolina, and you find the book on driving, and you open that book and you find driving DUI in North Carolina. Well, those are called statutes or sometimes codes. In South Carolina, it's the Code of South Carolina Laws. Bankruptcy has a strange name. Bankruptcy is called by chapters. Now, in your book, it's chapter 16, but that's not what this chapter means. Okay? The bankruptcy law in the Constitution has various files, various divisions, and they're called chapters. One that you may have heard about is chapter 13. Chapter 13 is personal bankruptcy. You don't have to worry about that in this class. But if you graduate and you're broke, and you can't get a job, and you've got debts, you can declare personal bankruptcy. Okay? Unfortunately, student loans can't be put on there. So, because that's not business, we don't do that. We cover chapter 11 and chapter 7. Chapter 7 is when the Banks Corporation is declaring bankruptcy. Maybe Twitter wants to declare bankruptcy before Elon Musk buys it. I think he's already bought it. But if you owe more than you have, if you owe more than you're going to receive, if your basic business equation, profits equals revenue minus expenses, if it's out of whack, then you have the option of declaring bankruptcy. When you declare bankruptcy, you owe none of that. None of them. They're wiped clean. You don't ever have to repay them. Doesn't matter if it's $1,000 or $1 million or $50 million. If you declare bankruptcy, you don't have to repay your debts. But there are some things that have to happen. So chapter 7 is called liquidation. We are going to close the business. We do not have enough money to run the business. We don't anticipate getting enough money to keep the business open. So we have decided we are going to liquidate our assets. And this is the way it happens. There is a bankruptcy judge, and this is a federal case because it's coming out of the Constitution. The bankruptcy judge is appointed for life. It's a great job. They're paid a lot of money, and the Corporation A wants to declare Chapter 7, so they file a claim with the bankruptcy judge that says, we want to go bankrupt. Now, who doesn't want Corporation A to go bankrupt?
People need money from them.
The people they owe money to. All right? So, the creditors, this is the debtor. The creditors, the stockholders, IRS, the workers, they can all get together, or they can independently get a bankruptcy lawyer, and they file a claim and say, you know, this creditor is Corporation B. They say, we want all of our money. We want all of our money. And we want to be paid first before the stockholders are paid or before the workers are paid. We want our money. Well, who makes that decision? The bankruptcy judge appoints a very important person called the trustee. And the bankruptcy trustee is a lawyer, makes about $300,000 a year, maybe $4, works pretty much 9 to 5. It's the best job you can get as a lawyer, probably, being a bankruptcy trustee. And they work for sometimes years being a trustee. And they develop a good relationship with the bankruptcy judge. Lawyers that do bankruptcy work usually don't do any other kind of work. Okay, so the lawyer that does your will, or the lawyer that represents you on your DUI, or the lawyer that does your divorce, doesn't do bankruptcy work. I mean, they probably know how to, but everybody gets referred to a bankruptcy lawyer. All right, so the bankruptcy judge tells the trustee to gather assets. Now, that's easy if Corporation A has 10 trucks sitting in the parking lot. That's easy if Corporation A has machinery sitting in a warehouse. They can claim the machinery. They can claim the land. But it's harder if Corporation A has money in the Bahamas, or money in the Turks and Caicos, or, you know, if they have money that they've hidden, or if they claim that that's not part of their business, it's part, you know, it's in their wife's name, whatever. The trustee's job is to collect everything that they owe. All the bank accounts, all the savings accounts, not of the individuals. You remember when you do forms of business? And when you do forms of business, and the corporation is a corporate shield, all right, well, it's the same thing in bankruptcy. They are going to collect all of the corporation's assets. While they're doing that, if they find that the CEO is not driving a Mercedes and has a private plane, you know, and is flying to Hawaii every weekend, they're going to go after that car and that plane, and they're going to see if he's got any money stashed away somewhere that really belongs to the corporation. And the CEO says, oh no, that was from my salary. And it's the trustee's job to figure out whether it was his salary or whether he was actually stealing money. So you gather the assets for the trustee. The trustee also totals the debts and puts them in priority. Right? Who is going to get paid first? So if they gathered assets and it is $5 million, and the total debts are $10 million, Corporation B does not get the whole $5 million. The trustee has to say, okay, Corporation B gets 50% of it, the stockholders get 25% of it, and everybody else gets a dime on the dollar. And the trustee then gives the court, he can go bankruptcy, we found all the assets, and this is how they ought to be paid. Corporation B should get $2 million, the stockholders should get $1 million, and everybody else should get 25 cents on the dollar or whatever. And when that is over, when that's done, and it can be done in a month, it can be done in a year and a half. When that's over, the bankruptcy court issues a discharge, and that ends the bankruptcy. Corporation A is now out of bankruptcy. They can start tomorrow making the exact same product. They can start tomorrow if anybody will lend them money. You know, if they get sell some stock, they can start over with it. Okay, they no longer owe $10 million. Their $5 million is gone, but they no longer owe the 10. And this is pretty simple explanation, but that's exactly how it happens. That could happen for a local mom and pop restaurant. You know, maybe the father dies and the grandmother just can't run the restaurant, and none of the grandchildren want to step in and help. So the lawyer says, look, let's just liquidate. Let's just sell the building and declare bankruptcy. Or it can be done for Enron, which was 20 years ago, which was a gas and oil company that was billions of dollars. Any questions on the liquidation? So I give you an exam, and you have formed a corporation or a partnership or an LLC, and I work you through a contract or a management or maybe a litigation, and at some point in the fact situation, I say that their assets are less than their debts. They have too many debts and they may not be able to stay in business. That's your hint. All right, that means that you've got to, when you get through the whole test, you've got to say this is also a bankruptcy issue. Corporation A can declare bankruptcy, and just walk me through this. Again, the most important thing is you recognize that it's a bankruptcy case. So if you recognize it's a bankruptcy case, remember if I had put all of this up here, you know, bankruptcy is just, I think it's number 15, chapter 16. All right, chapter 11 is a little more interesting. Let's call it reformation. We've got a judge. We've got Corporation A. We've got Corporation B and other creditors. And Corporation A tells the judge, we can't pay our debts right now, but we will be able to do it in 6 months. You know, we make quilted jackets. We make quilted hoodies. We make long underwear. And it's 100 degrees outside, and our sales have just dipped down more than we thought that we would. We knew that they would dip in the summer, but we didn't know they were going to dip to this extent. And we're having trouble selling our items, but we know when it gets cold, they will sell like wildfire. So we need relief. And so he asked the judge to give us some relief. Corporation B says, I want my money. The trustee, in chapter 11, the trustee goes to Corporation A, and I have seen this done. They go to Corporation A and they lock the doors with a padlock and a chain, and they take every key out of there. They take every computer out of there. They take anything that's not nailed down, so that Corporation A won't walk away with it. And the trustee then runs Corporation A. They become the CEO. Corporation A, they tell Corporation A, take a hike. And all of the workers, or all of the management, and all the CEO, they leave. The trustee comes in the next day, say, all right, what do we got? How many workers do I have? What do we need to sell? What can we do with these winter coats? Can we sell them cheaper somewhere else? Can we send them to China and sell them? The trustee does everything he can to keep Corporation A in business. In the meantime, Corporation B gets zero. But the trustee and the judge tell Corporation B, here's the deal. You can file a claim and try to force them into liquidation. You can try to file a claim and try to make them pay you, but you're probably only going to get a dime on the dollar. They just don't have any money. You know, all they got's a warehouse of quilted hoodies. If you just wait 6 months, or if you just wait a year, I promise you we'll get you all of the money you're owed. So Corporation B has a decision to make, and if they can withstand it, if Corporation A is their only debtor, that makes it hard. If Corporation A is the only debtor, then the creditors can tell the judge, no, it can't be an 11, it has to be liquidation because we have to get paid. But if they're not the only debtor, then the trustee can tell Corporation B, just wait. Okay, and we will get you your money at some point. I don't have any statistics over which is filed more than the other. My guess is Chapter 7 is filed more often because businesses are just closing up when the economy is bad. When the economy is good and the trustee can go, and the trustee's got more things to do than run a business, so obviously they hire a CEO to come in to run the business. But they have more to do than just run businesses. So probably Chapter 7 happens more often than Chapter 11, but Chapter 11 is a great option. All right, it gives people the opportunity to stay in business without having to lose their business. Keeps the stockholders from having to lose the stock. Okay. Any questions on bankruptcy?
So on a test, will we have to decide between Chapter 7 and Chapter 11?
All right, great question. I give you a bankruptcy issue on the test, and that's easy to do. I just simply state that whatever business you formed, they owe more than they have, and you say there's a bankruptcy issue. You aren't the CEO, so you can't make that decision, Maggie. So what you have to tell me is they have the option of Chapter 7 or Chapter 11. Now, at the end, when you talk about some creativity, if you want to say, in my opinion, they ought to do Chapter 11 so that they can stay in business, your grade goes up. But your main answer is you have to give both choices, right? Because you don't know enough facts to make that decision. So if you say, my corporation needs to make a decision to go into bankruptcy, and it would either be reorganization or liquidation, Chapter 11 or Chapter 7.